This is a dual event, right? This is a kind of normal session of Criminology 217, Crime and Justice in Maine, which is an elective here I teach at USM. And it's also, if we didn't have a snowstorm today, we'd be at Talbot Lecture Hall in Luther Bonney as part of a, public lecture called Conversations in Crime and Justice in Maine. Where we're hearing from, people working in and around the criminal legal system in Maine. So, these talks are organized by the criminology department with support from the USM's CCD. What is it? Well, I forget the acronym, but from an office at USM called CCD. And today we're very lucky to have with us Tina Heather Nadu. She is a criminal defense attorney and executive director of the Maine Association for Criminal Defense Lawyers. Tina Heather Nadu is a native of Madawaska, Maine, who received her BA at Bowdoin College and her JD at Maine School of Law. As a law student, she served as a staff member and later editor-in-chief of the Maine Law Review. After completing law school, she clerked for the Honorable Justice Donald G. Alexander of the Maine Supreme Judicial Court. Tina joined Daniel G. Lilly Law Offices in 2011, where she represented clients in civil matters, including medical and legal malpractice and civil rights. Tina has maintained an extensive and varied criminal practice. In 2015, she opened her own solo practice in Portland, Maine, to focus on her true passions, criminal defense and appellate practice. Since that time, she has represented hundreds of people charged with everything from misdemeanors to murder. She has earned a reputation as a tenacious litigator who does not back down from a fight, particularly when her clients' liberties and livelihoods are at stake. And just as a quick side note, our last speaker in this series was Randall Liberty, the DOC commissioner, and he asked who else was coming, and I said Tina Nadu was coming next, and he was like, "Ooh, I wouldn't want to go against her." So that tenacious reputation is well known in Maine. So every year since 2013, Tina has been recognized as a super lawyer's rising star in criminal defense. In 2020, she was recognized with the Maine Equal Justice Hero Award. In 2019, she was awarded the New England Educational Opportunity Association's Achiever Award. In addition to her private practice, she serves on the board serves as board president for Maine Equal Justice until 2020, and she has worked as the executive director of the Maine Association of Criminal Defense Lawyers since November 2017. She served on the Maine Supreme Judicial Court's advisory committees on the rules of appellate practice. So Tina argues regularly before the Maine Supreme Court and has litigated dozens of criminal appeals. Tina has worked on several post-conviction review matters. She accepts appointments from the Maine Commission on Indigent Legal Services, and she also engages with private clients on criminal matters. So thank you, Tina Heather Nadu, for being here.
Yeah, thank you, Professor McQuaid. I should have provided you a very small bio. You got the whole bit and caboodle from the website, so that's a lot.
I did. I actually edited it down a little bit, but there's a lot of good stuff to highlight. So what we're going to do for this event, I have a couple questions and we'll go through those and then we'll open it up to Q&A. So the first question, is just on your background. I know that was a pretty extensive intro statement that I lifted from your website, but I always like to start these events by asking speakers a bit about your background. So I wonder if there's anything you'd like to add, or if there's anything, that really motivated you to pursue this career that's kind of not in your, greatest hits list of your professional career.
Sure. Thank you. Thank you again for that introduction. And hello, everyone. I am very sorry that we are not in person. I was looking forward to that. I'm sure like most of you, I'm sick of Zoom. I believe my niece, who's about to graduate from USM in May, is here today as well on the line. And I know that for college education has been a lot different under the age of COVID. So I appreciate your patience. And I'm very excited to speak with all of you and answer your questions. And there she is. She is here. Ariana, class of 2023, coming through. Very proud of her. So some of the things that were not discussed that I think really did drive me to the kind of work that I do include some of my academic education at Bowdoin College. I was a history major. I focused specifically on African American history and African history. I was originally intended to be a history professor. I went to graduate school for a hot minute in African history. But, you know, delving deeply into the lives and stories of the African American experience in America and how closely that's associated with civil rights and how closely that's associated with our criminal legal system and deprivation of civil rights really piqued my interest. Also, I was a high school English teacher for 3 years down in Mississippi in the Delta. I was part of a program that has its issues, but at the time, it was a really good opportunity for recent college graduates. I was with Teach for America. So I was stationed, and we did refer to it as being stationed in Greenville, Mississippi on the Mississippi River for 3 years. And for those of you who are not familiar with the politics of the Southern states, the Deep South, Brown v. Board of Education came through the Supreme Court case that said segregation in public education is illegal. And that was in 1954. The high school that I was actually stationed to teach kids was opened in 1954 as an all-white high school. And for the next 20 years, there were still no Black students, even though Black kids made up 60% of the Greenville population at the time. And by the time that I taught there in the early 2000s, it was all Black because the white parents pulled their students out and set up what we called Christian academies. I call them white Christian academies because essentially that's what they were. So even though the law of the land says segregation is not legal, because it was not a decision of the public school itself, but the parents themselves to create these private schools, it somehow is legal. So segregation in Mississippi is still very much a problem. Segregation in a lot of big cities throughout this country is a big problem. So working with my students and living in a place like the Delta, that is, racism is systemic, it's generational, it's pervasive. Those things really did inspire me to look to a career that I could help people in a different capacity. Teachers are great, we need great teachers, but there's a limitation, I think, with what change can be wrought from individual teachers teaching their classrooms. So those two things, along with just some other life experiences, kind of led me to go to law school at Maine Law. So it used to be across the street from you all. Now it's in a big fancy building downtown, so that's cool. Didn't have that experience at all. But pretty soon after I got to law school, I had a professor named Melvin Czar, Professor Czar, who was an amazing professor. He also was one of Martin Luther King Jr.'s, Dr. King's attorneys down in Mississippi during the civil rights movement. He actually helped litigate things to allow marches and protests and other kind of big legal issues throughout the civil rights movement. So working with him and some other instructors at the law school really kind of set me on a path towards criminal justice, but also racial justice.
Great, thank you, Tina. So you represent a lot of clients that are indigent, and I wonder if we can discuss two issues related to that. First, just what is it like to represent poor and otherwise marginalized clients? You know, what have these experiences taught you about the criminal legal system and even American society in general? And then second, like the big policy question in Maine, which is like, can you explain how the Maine Commission on Indigent Defense differs from a public office? and why you and the Maine Association of Criminal Defense Lawyers have advocated for the creation of a public defender's office.
Those are huge questions.
So that's the rest of the hour,
Absolutely
right?
massive questions. So my day-to-day work is, even though we don't call it public defender in Maine, it really is what we do. We defend people who are accused of crimes who cannot afford attorneys on their own. Okay. So to pull it back, the Sixth Amendment in the United States Constitution guarantees people the right to have the assistance of counsel in criminal prosecutions. My role in this system is literally in the Constitution. We're the only ones actually in the Constitution. Prosecutors, police, even judges are not in the Bill of Rights as a guarantee for anyone. And in 1963, so we're approaching the 60th anniversary, the US Supreme Court declared that if a person cannot afford counsel, the state must provide counsel if that person is facing imprisonment. That means not just provide counsel, pay for counsel. This is literally a directive on the states that they have to pay for people to be represented in their criminal courts. So in Maine, and I'm kind of blending the things, but I just want to, make clear, we have this thing called the Maine Commission on Indigent Legal Services. It's a mouthful. Indigent just means poor. It's just another fancy word that we mean for poor, or people who qualify for representation because they don't have enough income to pay for a private attorney. Private attorneys are expensive. I also do that work. I charge a lot more for private clients than I get paid through the commission, but this is something that my heart is very much dedicated to, which is ensuring that poor people get excellent representation regardless of their circumstances. So as far as representing people, as a defense attorney, I am the counterpoint of a prosecutor or a district attorney or a state's attorney. They're called a lot of different things. In Maine, we call them prosecutors or assistant DAs. I know most of you probably watched Law and Order SVU, and like the 1,000 other iterations of that show. But one of the things that always ticks me off about Law and Order, and there's a lot of things that tick me off about Law and Order, even though it is compelling television, is that they begin their show every time in the criminal justice system. The people are represented by two separate yet equally important groups: the police, who investigate crime, and the district attorneys, who prosecute the offenders. These are their stories. That's a load of garbage. No offense to the creator, Dick Wolf, but that's a very sensationalist view and very police-centered view of what those two entities do. I literally represent people as a public defender. The way that that's construed is that my people, my clients, are not part of the state of people that we actually are supposed to care about, and that's just not true. When I am appointed to a client, we don't call them offenders. I think that's just 90s garbage, leftovers stuff. But anyway, when I'm appointed to a client, oftentimes they are incarcerated. Before COVID, that would mean I would go see them at the jail, right? They are being held without bail. I want to commend Professor McQuaid for having such a wide-ranging syllabus. I know you guys are reading about a ton of stuff, including bail. But for those of you who might not have got to that point yet, bail is basically just cash money, usually, that the court requires for somebody to post before they can be released before trial. Some people can be released without the cash component if they are appropriately supervised by Maine pretrial services or something like that. But oftentimes my clients are poor. And even if bail was only $50, they can't make that. So for my clients who are facing serious charges or even just less serious charges with a bail amount, most of my conversations with them would be at jail. During COVID, it's like this. This is why I'm sick of screens. It dehumanizes things a bit. It makes it more convenient for sure. But meeting with my clients, listening to them, introducing myself, explaining the process, addressing their questions, And then in the future, reviewing discovery or evidence with them, investigating the case. All of that stuff is really important to keep the client involved at every step of the litigation. When clients are out of custody, when they are not incarcerated at the local jail, it's a lot easier to work with them because they're out there in the community. They can come to the office. They're not being restrained. They can stay in their homes if they have homes, maintain employment, keep custody of their kids. All of these massive things that could be in jeopardy if they were to be held in custody are not there if they are released, out of custody. My work involves a lot of legal research, a lot of, like I said, reviewing discovery. Discovery is a fancy word we use for police reports, witness statements, photographs, video evidence, anything and everything the state has collected during the course of their investigation. It's my job to review that thoroughly, allow my client to review it thoroughly as well, and see where the holes are. The biggest job of the defense attorney, I'm going to say two. The first is to humanize your client. And by that, I mean, when we see things like calling them offenders or criminals or other less nice words, quite frankly, in the media, it's our job to actually show them as a real human being, whether it's to the prosecutor, whether it's to a judge, whether it's to the public at large. Our job is to speak on behalf of our clients, not for them. They have voices, but as we might talk about later, there's certain reasons why having a lawyer speak for you is a good idea. So humanizing clients, but also what we call putting the state to its proof. You might have heard this phrase before. The state must prove all criminal charges beyond all reasonable doubt. That's a very fancy phrase. What does that mean? It means that the charges themselves are almost certainly true. Our job as defense attorneys is not to prove anything. It's to see if the state can actually meet their burden. Where are the weaknesses of the case? Where are their inconsistent statements? Is the witness going to actually show up for trial? Did they get this wrong? Who's lying? Who's telling who this, that, and the other thing? So being a defense attorney is kind of nice because the state has to show all their cards and we get to punch at them. We get to punch at their evidence and see where the soft spots are and advocate for our clients. Sometimes there's not a lot of weak spots, and that's when we can talk about sentencing. Maybe we'll do that later, but that's part of the humanization as well. So in Maine, we don't have public defenders. We have appointed counsel right now. We have just very recently 5 public defenders. So people who are paid by the state, they are salaried employees with benefits who ostensibly have some sort of office and supervision, who go out to the rural areas of Maine to kind of fill the gaps of representation there. But the vast, vast, vast majority of people in Maine who qualify for representation are represented by appointed counsel. Appointed counsel are certified by the Maine Commission on Indigent Legal Services to be well-trained enough or experienced enough to take certain case types, and then judges go down the list and basically appoint people. There's huge downsides to that system. The one upside is that there is a lot of freedom there, but what we're seeing is the quality of representation is not guaranteed in this system. I am MACDL's executive director. If I'm going to say things about why I think public defender offices are a good thing, I'm not speaking on behalf of MACDL necessarily. I don't think MACDL has ever formally said that they support that. But me personally, Tina, sees the advantages that the state has by having 8 district attorney's offices throughout the state. They have 8 districts and they have the attorney general's office. They have people who can mentor. They have people who can train you. They have office staff. They pay for your parking. There's just a host of reasons why having structured, supportive, supervised defender offices, I think, would go a long way to ensuring effective representation. Because going back to the 6th Amendment, it's not just to have an attorney, it's the effective representation of counsel. You are guaranteed that your counsel, your attorney, is effective, that they're going to do a good job by you, that they have the experience, training, and resources they need who defend you effectively. I can't say that Maine has met that goal. I don't think we come even close. I'll speak probably more about this later. There's recently been in the news something that I've been advocating for quite some time, and it's actually quite surprising that it went through the way it did, to raise the hourly rate. When I started doing this work, it was $50 an hour, which for a college student sounds fabulous. That $50 an hour would go to salary. Don't forget taxes. If you had any staff, it had to come out of that, et cetera, et cetera. If you have an office, you know, you have to pay that out of pocket. What just passed was $150 an hour, which again, sounds like an extraordinary amount. And I take that, I own that. I can break it down for you why that's the appropriate amount. And that's because that gets us as close to parity or equality with the prosecutors as possible as far as resources. All the things the prosecutors don't have to pay for or that are included in their benefits, or that are just things that the state pays for regardless, just because you're a prosecutor. That's what we're advocating for on the defense side. So that just happened. It's a temporary thing. We're hoping that it gets extended through the next 2 years. So I'm going to shut up about that because there's just too much to talk about. And I was hoping to get to questions about that later.
Great, thank you. So next question, yesterday, some of my students observed in custody arraignments, which is when the defendant appears in court to be formally charged and bail is set. So in recent years, bail reform has been a big issue in Maine and across the country. I wonder if you could, talk a little bit, share your thoughts on bail reform, and specifically, how has the bail reform passed in 2021 impacted your clients? The new law eliminates cash bail for Class E misdemeanors, which are the least serious crimes such as littering or drinking in public. In your opinion, is this reform sufficient? If not, what else do you think needs to change regarding bail?
So that's a great question. And I'm sure maybe some of you saw me yesterday. I was surprisingly on the in custody list yesterday. I was 20 minutes before that, I was appointed to a man who's been accused of homicide. So he was making his initial appearance yesterday in court. Because it's a homicide, bail wasn't discussed, but typically for the vast majority of cases, a bail argument is heard at their initial appearance or arraignment. Bail reform came about for two reasons. The first is that when people are accused of a crime under the Constitution, they are supposed to be presumed innocent of that crime. They have not been convicted of anything. These are accusations. And to infringe upon their liberty, that is not something that the founders actually intended in the way that it's evolved into. The second reason is because bail, cash bail specifically, has had a disproportionate impact, obviously, on poor defendants. And because of the way our system is set up, particularly poor clients of color, bail, cash components are huge. And when people, as I indicated before, are indigent or poor, they can't pay cash. And essentially their liberty is being deprived to them because they are poor. Literally because they are poor, not necessarily because they're any more dangerous than a rich person who might have committed or be accused of committing a very serious crime, but just because they can't afford to pay bail. Maine struggles. We're a little bit behind the times here, and for big political reasons, I think sweeping criminal legal reform is not on the horizon. So what happens is we have wonderful advocates in the state. And in my work with MACDL, I am I don't want to say a lobbyist because that's not really what I do, but I do a lot of advocacy in and around these issues. People got together and proposed bail reform that would hopefully eliminate cash bail altogether. If there's a issue with someone being a flight risk or a sincere danger to, say, their alleged victim or society as a whole, then that's an argument, but cash shouldn't be part of that equation. because there has never been a study that indicates that just by setting bail does someone is someone more likely to show up for court or not. It's just not a thing. I know we think it is, but it's not. So what happens is there's big ideas that are brought to the table. And the way the legislative process works, and I think you're going to have some wonderful speaker about that later on this class, those ideas get watered down, and it's because it's by consensus. So in Maine, yes, we have this new law that eliminates cash bail for most Class E misdemeanors. For most of the Class E misdemeanors already, cash bail typically was not being set, frankly. And I think that's why prosecutors could buy into it a little bit more, because it didn't really change things too much on the ground. They knew this, but it's a step in the right direction. I know that there's been a lot of pushback throughout the country in any place with bail reform. I think New York is a great example, where law enforcement and other, kind of conservative small c people were really pushing against bail reform, saying it's going to open the floodgates of criminality. And they were saying this, it was already happening even before the bail reform got implemented. So it really undermines some fantastic work that was done by advocates in New York State regarding cash bail and regarding just, for what crimes can someone be incarcerated pre-trial in a place like Rikers Island, which from all accounts is hell on earth. So there's been a lot of scaling back of bail reform before it could even really take effect. But the parts that have shown a lot of progress as far as keeping people out of jail and actually reducing crime. Because when you keep people in their communities, you keep them with their families, you keep them employed, you keep them in housing, you keep them on insurance, all those things that help people get through their days and hopefully address some of the, and let's not forget, engage in things like mental health or substance abuse treatment, which are huge things that, you don't get when you're incarcerated. So bail reform is an ongoing fight. I would certainly hope that in the end, evidence wins out over rhetoric. But with criminal legal reform, the thing that you learn first is that people feel things with their heart more than their head. So you really have to meet them where they're at and try to show them that bail reform is not the end of the world, unlike they say. So.
Well, thank you. Cumberland County has a new DA, Jackie Sartoris, who assumed office last month. She was elected as a reformer, and she'll be speaking next month as part of this speaker series. I wonder, what are your thoughts on the so-called progressive prosecutor movement? What do you hope or even expect Sartoris to accomplish? And then what challenges do you think or limits do you think she'll come up against?
So thank you for that question. I did review your syllabus, and I want to commend you on having such a wide array of speakers for your students to listen to. The one thing I'd say to the students on the line here is, when you're listening to people on any issue, and you're trying to determine credibility or good faith, I just want to encourage you to take with a grain of salt, or a few grains of salt, statements made by people who have an investment in the status quo, meaning that they benefit to keep things the way they are as much as possible. Okay. I'm going to call myself a public defender because that's really what I do. As a public defender, my goal is to make myself obsolete. I do not want people charged with silly crimes. I want people to get the help they need in the community to address whatever issue has led to them committing crimes in the past. I don't want to have to be in court fighting for freedom for clients who should have got the treatment years ago. I don't want to have to exist in this role. Okay. I want to make myself obsolete. I want to make this thing obsolete. But this is the problem. Prosecutors, law enforcement, etc., they have a ton invested in keeping things at the status quo. Now, you might say, well, Commissioner Liberty, he's talking about all this great stuff going on at the prison. Sure. Prison is an inherently violent place. Jails are inherently violent. Criminal legal system is inherently violent. We are incarcerating people and locking them up. Okay, let's not be cute about that. And we can expand the system to include in the carceral system, mental health treatment, substance use treatment, counseling, trauma intervention, all that stuff, great. Now it's all under that umbrella of the criminal legal system. It's all under that carceral system. They're actually expanding their power. So I just want to be clear that when you are listening to people who are so invested in the system remaining the center of how we address these issues, I want you to be critical of that. You should be critical of everyone, but just seeing where they're coming from. There are statements that are going to be made that, Commissioner Liberty is a progressive prison warden, essentially, and that DA Sartoris is progressive. I don't know what that means because I haven't yet seen a progressive prosecutor in Maine. And I think there are limits because the initial response, the things that make these laws criminal is the potential for imprisonment. The limits of progressivism in that whole, I don't see it. I don't see how that's the thing. Might some people not be charged with crimes? Great, I haven't seen that. Might some people, we should step down on bail arguments on these types of cases, even if the legislature doesn't force us to. I haven't seen that. This person clearly needs treatment. They've had 20 years of crimes, all drug and theft related. He needs to go to treatment, not prison. Haven't seen that. So I think a political campaign is very different than practice. And the political campaign that was run this past session with the primary essentially deciding the winner, there was a lot of stuff talked about that has no basis in reality. And that frustrates me. And she's new, and I'm hoping for more, but I cannot say that that is going to be the thing that saves us. I don't think in this system with the judges we have and the prosecutors the way they are, the legislature and the governor the way she is, progressive prosecution is not going to save anyone because the first response will always be, should this person go to jail or not? That's not good.
Well, thank you for that. So now let's talk about the other end of the, from entering incarceration to exiting it. So Maine has no parole, which when I tell students, they're sometimes surprised. In 2021, there was an effort to restore parole that failed. So I just wonder, if you could speak to this, what your thoughts are, if you've been involved, if you think parole can be restored. Do you think the ad hoc pardons that the governor does from time to time, are they sufficient? What or that the
Which
governor can
ones?
do?
Those exist. Anyway. Yeah, parole. So I'm trying to do a pop culture reference. Might be dating myself. The Shawshank Redemption. I'm sure most of you have seen it. It plays constantly on TNT. You'll see that Red, about every 10 years, goes before a panel of very severe looking white people. So Morgan Freeman's character, Red. And essentially, the ultimate question for them is, have you been rehabilitated? And, he gets denied over and over again. And what he's going for there is a parole review board. So they're determining, he has this big sentence, should he be released early on conditions because of, his likelihood to not reoffend? Has he truly been rehabilitated? As he says, whatever that means. So that's the old way. Maine got rid of parole, meaning that people who are sentenced to a huge term of years had no way out. They might get a little good time, but if you're convicted of a crime like murder, for example, If you're sentenced to life, that means to death. You're going to die in prison. We don't have the death penalty in Maine, thank God. But a life sentence truly means life in Maine, your entire life. If you are 30 years old and get sentenced to 40 years, people don't live that long in prison. The life expectancy is significantly lower. That essentially could be a death sentence as well. So in 1976, when Maine adopted its criminal code, it took away parole. They thought it was too lenient on people. So what's happened over the course of these more than 40 years is that Maine's prison population has gotten older. There are people who are in their 70s and 80s who have not been a risk to anyone for a long time, who have no way of getting out apart from what Professor McQuaid said, a governor's pardon, which are, shall we say, few and far between, or a commutation, which is a fancy way to say a sentence reduction. Those things just really don't happen, especially for incarcerated people who have ever been convicted of anything, what we would call violent. So what parole would do is essentially give these people hope. That after a certain amount of years, they would be able to apply for release if they have established this, that, and the other. Things like, have they been working hard? Did they complete an education program? Have they addressed any violent tendencies? All of that stuff. And then, depending on how that parole board would be constituted, the parole board could decide to let them go on parole, meaning they would be subject to supervision and conditions of release for a set amount of time in the community. So, it's a complicated issue. I think it's really the place of compromise. The compromise position, I think, is asking for parole rather than just letting people out after a certain time. But it's an upward battle, uphill battle with this governor. Governor Mills is a Democrat, so people can read into what being a Democrat means, but she is also very pro law enforcement. She was a district attorney for a long time. She was the state's attorney general for a long time. She led the charge to keep 0.2 grams of fentanyl or any substance containing fentanyl or heroin a felony, meaning punishable by up to 5 years. We are not dealing with a governor who has control over the system as someone who is lenient or accepting of people's ability to change. It's a very tough political situation. There is movement in the legislature, but I think there's a lot more work that needs to be done. There's been some great work done already, but I don't think we're there yet as far as getting the critical mass of legislators or the governor to buy in to this proposal. In the meantime, people die in prison.
Great. Thank you for that. So my last question before we open it up to students in the audience is, just to ask you about advice for students interested in careers in law. Many criminology students, are interested in law. We have an accelerated pathway with Maine law. So I wonder what advice you can give to them. And then for students interested in criminal defense in particular, what do you think would make someone well suited for this work? What are things you wish you knew before you began? Just, anything that you would like to tell people thinking about this type of career.
Sure. So I think the first thing I would say is you don't have to be a lawyer to affect change in this area. Being a lawyer helps in some ways. You put a JD or Esquire after someone's name and suddenly people listen to you a little bit more, which I think is very strange, knowing the lawyers that I do. But I think if you have this sense, when you see something that's wrong or feels wrong to you, feels unjust, you don't like it, it's bullying, it's whatever. If that makes you want to either fight or puke, then I think you have what's in you to take up the mantle and affect change in this system with that kind of mindset that things should be fair, that things should be just. And if people are getting a boot on their neck, there should be someone fighting to take that boot off. There should be someone fighting for them and being in their corner. I think having that kind of worldview goes a long way, because for most of us, I think a deep sense of injustice is kind of natural. We see things that aren't right. We feel that. We know that in our hearts. And we should want to change that and help folks. So yeah, going to law school is a great way. You don't have to be a defense attorney. You can do policy. I also saw on this great wide-ranging syllabus, there's people who do advocacy in domestic violence spaces. And, I've represented a ton of people. We kind of compartmentalize, domestic violence, yes, my clients, some of them have been accused of domestic violence, but I also represent a lot of people accused of crimes who are also survivors of domestic violence or survivors of sexual assault. And here they are being re-traumatized by the very system that's supposed to help them. So being an advocate, working with our unhoused brothers and sisters, there's just a ton of things that are connected with the criminal legal system, mental health advocacy, et cetera, recovery. You're going to be hearing from people like Skye Goslin on juvenile justice, Courtney Allen on recovery and advocacy regarding decriminalization of drugs. Those are the experts. Okay, I don't need to talk about that stuff. I support everything they say. There are a ton of fields in and around these issues that desperately need people who care. And you don't have to have a PhD, no offense, Professor McQuaid, to be an expert in the field. Lived experience and being open to learning and fighting, all of those things can make you an expert in the field. And you do have a voice that's important.
Okay, so we have about a half hour left. So we have plenty of time for questions. There were 2 questions in the chat. We can start with those. If you have other questions, you can just raise your hand or pop them in the chat, whatever you prefer. So the first question was from a student in my class, DJ. And he asked, if offenders are not facing jail time, can they still be appointed an attorney by the state? Can they review and collect all the discovery that they need on their own if not appointed a lawyer?
Those are great questions. I'm going to fix the offenders part, okay? These are people who are accused of a crime. They are the accused, they are clients, they are human beings. Let's start there, okay? If they are not facing jail time, can they still be appointed attorney by the state? Yes. Sometimes when clients are facing possible immigration consequences, if they're not a citizen, a US citizen, certain low-level offenses like a little Class E misdemeanor theft could trigger things like deportation, right? So sometimes in those circumstances, even though there's no real risk of jail, a judge may appoint counsel. If somebody has significant mental health issues, what's the phrase that they always use? Floridly psychotic. So they're really, really struggling, okay, in the community, and they just need someone to kind of guide them, make sure they can access services, perhaps get an evaluation. Even if the crime itself is not really carrying a risk of jail, I have seen judges very correctly appoint counsel in those situations. For other people who are facing more typical run-of-the-mill charges that don't carry a risk of jail, that don't have any of those kind of sensitive red flags that might pop for counsel, yes, they would get the discovery on their own. They would get the paperwork on their own, the DVDs or a link to the video on their own. I see that often in driving cases. Even if you don't have a right to appoint a counsel, you always have a right to an attorney. You just have to pay for one. And it's really scary to me when I see very, very late in the process, people still without counsel, trying to do it all on their own. They have the right to, under our Constitution, they can represent themselves, but it's not often a good idea. I don't know if it was Mark Twain or one of those very funny old guys from the 19th century who said something like, he who represents himself has a fool for a client. And I would tend to agree with that. Even if you're an attorney, like if I was charged with a crime, I would not represent myself. I would definitely want someone doing that work for me and helping me and advocating for me. So I hope that answers your question, DJ, about that.
So we have one hand, but first we had another question in the chat. This was from Ella Dempsey Blair. It's also a student in my course. She asks, do you believe cash bail violates the Eighth Amendment? What are prosecutors' arguments for why cash bail should exist? Do they not see that cash bail only impacts poor people while the rich can pay their way out? Do you think a case will be brought to the Supreme Court in the near future?
These are really, really great questions. So to the first question, there is a prohibition against excessive bail. So then it becomes, what does a judge determine to be excessive? My personal opinion is if the client has no way of paying it, it's excessive, particularly for lower level nonviolent crimes. So I think there are times, many times, that the Eighth Amendment is violated. Unfortunately, I am not the arbiter of what constitutes an unconstitutional application of bail. So that's the US Supreme Court's decision. So I'm going to bump to your last question first. Do you think a case will be brought to the Supreme Court in the near future? Honestly, I hope not. Okay. The composition of the court right now is so conservative and so anti-criminal defendant that I would be very concerned that they would come down on a case that makes it impossible to argue excessive bail in any case federally. So I just hope not. I think with the status of the Supreme Court the way it is, the real reform will have to be done through state constitutional law. Every state has their own constitution as well, and fighting those battles with the state Supreme Court. So if there is a great case to come out of Maine about excessive bail, I would love to see it. What arguments from prosecutors about, okay, this is what I hear from prosecutors all the time. Your client needs to have skin in the game. My client's literal body is in the game, so they have plenty of skin in the game, okay? Cash bail only benefits people with money. The most dangerous person I've ever represented, and was that lawyer of the day, came from money. What he was accused of was extremely violent. And there was a lot of evidence of it. This was merely an accusation, and I'm still attaching the presumption of innocence, but the accusations were horrific. And the evidence that I reviewed was also horrific. Bail was set at a large amount. It was set at $15,000. He posted it 2 hours later, and he was out. And the alleged victim was terrified. Is community safer because he was able to post bail, whereas my client is charged with his third offense, theft, and he can't post $500, so he's going to stay in jail until he either pleads out or resolves his case another way? I don't think so. So I think prosecutors' arguments, when they don't hold up to scrutiny, when you really look at what they're arguing for, which is holding people in bondage because they can't pay a fee.
Okay, Jace, do you want to unmute and ask your question?
Yes, this is Daniel. I'm on Jason's computer. We're screen sharing right now. But my question is, do you believe indigent defense compromises the Sixth Amendment and provides inactive defense assistance of counsel?
I'm going to ask you to clarify your question. One, because your video audio quality isn't great, but I just am not 100% grasping it. So go ahead again. Try me again.
Okay. Do you believe the indigent defense system is inadequate and it essentially renders ineffective counsel during a trial because it could meet the second requirement of proof of prejudice?
Okay, so I think I got it. I don't think our system, the system we have in place, or quite frankly, any system in place in this country regarding indigent defense, guarantees effective counsel. I think there are great improvements that need to be made. I don't think it guarantees ineffective counsel, but it certainly doesn't guarantee effective or good counsel. it is completely under-resourced. There are no supervisors. There's no, I mean, they're kind of getting there with some training. But it really is nothing that objectively or qualitatively or quantitatively can be supported that we actually provide effective counsel to clients. Do some clients get effective counsel? I know they do. And I sincerely hope they do. Do some clients get ineffective counsel? I know they do. And that's not acceptable to me. But our system does not guarantee them that yet. It should. And it's really the obligation of the state to do that.
We have a question from Anna that says, do you have any testimonials from past clients that you had to analyze through deeper thinking? I don't know if you want to unmute and clarify that a little bit, Anna.
Yeah, and then we'll pop up to Shaylin's question after that.
Oh,
But
did I
go
skip
ahead.
one? I'm sorry.
That's okay. Did you want to clarify, Anna, about your question? I want to make sure I can answer it. I'm not seeing her on mute yet. So can we go to Shaylin's question?
Yeah, please do. I'll read it for
Okay.
everyone's benefit. It just says, what would you say is the most difficult part of your job as a criminal defense attorney? Do you often face negative public perception, moral dilemmas, intense time demands, emotional exhaustion?
Are you in my head right now, Shaylin? No, okay. So negative public perception is a thing. It's a thing, right? You know, like I said, hearkening back to Law and Order, the good guys are the cops and the prosecutors, and the scummy defense attorneys are here trying to get all these guilty people off. So yeah, I do think there's some public perception that is not accurate about greedy, shady defense attorneys. You know, the classic cocktail party question of how do you defend those people? How can you defend someone you know is guilty? You know, that definitely for the average person is a very deep question for them. And I say, I don't care if my client's guilty. That's not my job. I'm not the jury. I don't determine guilt. I'm here to represent a person, right? And I think negative public perception has also made things more difficult to advocate for increased pay or other supports that require legislative funding. Moral dilemmas. I don't really have moral dilemmas. It's not that I don't have morals. I certainly have morals, but in this arena, I am very clear about what my job is. And just because I defend someone accused of something doesn't mean I support what they're accused of. Oh my God, he's accused of molesting a child. Do you support child molestation? Of course I don't. Of course I don't. But my job is to hold the state to its burden as far as evidence, to provide that client with everything every single one of us would want to have done if we are accused of something, even that heinous, right? Intense time demands, yes. Lately, a little less, but the legislative session is ramping up. But yes, for many years I was working, you know, nights and weekends and really making myself almost sick over this because you can fill all the time with work. The need will always be there. But it's very important, no matter what job you have, that you set some boundaries for yourself. Otherwise, you're no good to your clients if you're sick and overwhelmed. Emotional exhaustion at times. Right now I'm doing pretty good. Like I said, I'm in a new office. So like life is looking pretty good from this view, which is the courthouse. So I can watch all the injustice from across the street. But going back to your big question, what is the most difficult part of your job as a criminal defense attorney? I think it's knowing or realizing, because it's realizing all the time, you can work your guts out. You can have the best arguments. You can do everything and then some, and you can still lose. And your client might still go to prison. And you can't fix all the injustices through that case. And you disappoint clients a lot. That's hard. Because if things were fair, oh, you fought so hard, you should win. You know, you have the law on your side, you should win. It doesn't always work out that way. And that can be heartbreaking because seeing clients in cuffs, going off to years, possibly to die in prison. If that ever gets easy for me, like I need to hang up the cleats, like I need to be done because that's just not right. So,
Great, we have another question from Emily. Or you want to keep going?
yeah, is Anna there to clarify her question? I just want to make sure I don't ignore it because I want to understand what she's asking. All right, maybe not. So Emily wrote, a lot of the discourse around bail reform appears to be about being too soft. I should put that in quote. Too soft on criminals. Do you think such a thing exists? How do we move beyond seeing the accused as criminals? Great questions. I think that's right. I think that is how it's framed. I think a lot of bail reform pushback is, oh, these soft liberal cities with crime running amok and blah, 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 blah. Yeah, I think that's definitely the discourse. I don't think that's the reality. I don't think people are just running around committing crimes. How do we move beyond seeing the accused as criminals? Well, we recognize the innate humanity of every person. We remember that if we care about the Constitution, we don't get to just pick and choose which parts we like as far as rights. These people are presumed innocent under our Constitution. They are not criminals. Often, I think conversations just open the world up. If you talk to someone for 10 minutes and you can't find something in common or something that you actually connect with them, I would be very surprised. My clients are not monsters. My clients, for the most part, are extremely poor people who have been living in extremely horrible circumstances for a long time, or something went off the rails really bad for them. They struggle with mental health issues. They struggle with substance use. They struggle with navigating trauma and brain development issues. It's a host of things. They are not criminals. They are humans who are struggling. So I think the question often becomes, I think the prosecutor is like, okay, so what are we going to do? Punish them, right? I think the question more becomes, how do we make sure this doesn't happen again? How do we make sure they're safe? And by making sure they're safe, that ensures more public safety. Locking people up when 95% of them are going to get out someday, more damaged and abused than they were when they went in, does not ensure public safety. It does not. Making sure people are cared for and supported, that ensures public safety.
So we have a question from Sarah Lumia. Would you say it's true that a public defender's job is to hold the state accountable? How hard is it to separate your personal opinions on a case from the job you have to do?
Good questions again. Like, you guys are really like upper level thinking, and I'm surprised it's an undergrad class, quite frankly. Would you say that? I think that's one of our jobs, right? To hold the state accountable, to make sure they're following the rules. They have an obligation to turn over evidence to us. We call it a Brady rule. They have an obligation not to coerce confessions and not inform people of their right to remain silent. That's Miranda. You guys hear that all the time. You have the right to remain silent. Blah, blah, blah. If those things aren't followed, and the state is not held accountable, our civil rights don't matter. So I think it's a huge part of our jobs to hold the state accountable. Separating my personal opinions on a case from the job I have to do. I think that gets back to the moral dilemma. I'm a human being, okay? It's not that the crimes that my clients have been alleged of committing don't bother me, as a human being. Of course they do. But I think if you can't get over that, essentially, and focus on the job at hand, you're not doing your job as a defender. You're responding as a citizen, and that's not really helpful to your client. So I don't find it personally hard, but I've been doing this a while. I think the newer attorneys struggle with it, and that should be expected. I think toughening up kind of sounds really callous, but it's true. The longer you do this, you do develop a thick skin, and you can more easily focus on the job at hand.
Okay, we have another question from Ariana. Are there times in which your clients show any form of maltreatment towards you? How do you handle that? If there are people who have diagnosed mental disorders, or you have a reason to believe they have mental disorders that are undiagnosed, do you have to approach these clients differently? If undiagnosed, can you request evaluations?
Okay, those are great questions. Thank you so much, Ariana. And that's my niece who, again, I think is studying psychology. So it makes sense why she'd be focused on these issues. So yes, if I actually have an obligation as a defense attorney that if I think my client is not competent, meaning they don't understand what's going on or they're really struggling, I have an obligation to ask the court to order an evaluation on that issue. If there are other issues going on, like things that were manifested during the course of the alleged crime that pop red flags for me that could be about mental illness, then I also have an obligation to investigate that and request evaluations. And that happens a lot. I would say more often than not in crimes involving violence, there are things during the course of representation that certainly raise concerns with me about whether or not my client was in their right mind then or in their right mind now. So it can be very helpful to get evaluations. Certain evaluations can be done confidentially, so the prosecutor doesn't see them unless they come back favorably, I guess, for your client. But that's something that I do a lot. As far as clients showing like some sort of maltreatment or not being very kind to me, it happens. It's rare, but it happens. And what I try to do is not take it personally, which can be hard, but this is how I have to picture it. And this is how I want you all to picture it. Every morning, how many things do you need or things you need to do to feel comfortable, like you're ready to start your day? Good night's sleep, pajamas, access to a hot shower with your nice shampoo, face products, maybe makeup, maybe a coffee from Starbucks, maybe some of you hitting the vape, whatever it is, there are a lot of things we need to feel human in the morning. When my clients especially are incarcerated, they have none of that. And they can't yell at the prosecutor. They can't yell at the judge. If they yell at the corrections officer, they're going to end up in segregated housing or solitary. Let's be clear, segregated housing is solitary confinement. They can't scream at anyone on the phone because those are all recorded. So who are they going to vent at and emote at? Us, because they have us. And you take it and you listen. And sometimes you actually get things that are helpful when they are, raging, what it might feel at you, but they're really just raging and you're there to hear it. So there are things that are inexcusable. And there have been a few times, and I mean like less than 5 times in my career where I've had to withdraw. But I always try to keep in mind, like, what would I be doing and saying if I was in that position, like that exact position? I might not be my best self, let's just say, and my attorney might get some of the brunt of that. So it's part of the job, but there are things that are non-negotiable, threats to kill me, things like that. I don't think I, want to follow that client much longer because it really does impact your ability to be zealous. And that means like a strong advocate for them. And they deserve better. Maybe they'll work out with someone better.
We have more time for questions if anyone has anything they'd like to ask.
I have a question.
Go for it.
Are there like any opportunities for undergrad students who are kind of looking at your field of work to kind of, pop in and do some sort of internships, anything, just to kind of be around that field and get a glimpse of how it is, especially as undergrads, because, kind of for the most part, I've been getting a lot of no's is nothing for undergrads and stuff like that.
Awesome question. I would say that, yes, there is a place for undergrad. I had an undergraduate student who volunteered himself from Bowdoin last fall, who helped me collect information on potential jurors for a jury selection. And he was wonderful. You don't have to be a lawyer to do that. Actually, he was great because he was way more adept at some of the tech, like social media stuff than I was. So I got a lot of value out of that. And the other thing is with this, at least hopefully not just temporary, raise to $150 an hour, people can afford from that to hire an intern and pay them for what they're worth. I don't think people should be working for free. If you guys are getting offers to work for free and you can float it because you're a family, cool. It shouldn't be expected. You should be paid for your work. And hopefully with this opening up, more people will be open to hiring interns. And the law school, it's just down the street. It's right on 4th Street. They often have opportunities in their clinic for undergrads to kind of either assist there or, you know, do some, what's it called, work study there. So all good options and a great question.
So also just a quick thing, Tina, we have an internship program in the USM Criminology Department. So
Oh,
we can
cool.
send you students to work for credit, and that's something we can talk about if you're interested.
Oh, that's cool. Yeah, now that I have an office and like space for people to work, that might be actually a great idea if for the trials coming up. So good to know.
All right, so we have another question from Emily. Do you think there are any limits to individual action in a system that many say is inherently flawed? In other words, how do we work within a system that is broken?
Dropping like profound questions towards the end. Okay. So I wouldn't say the criminal legal system is broken. I would say it works exactly the way it was intended to work. It funnels poor Black and brown people into prisons. And we're very good at that. We're very efficient. That's the catchword of all judicial stuff is how efficient are we, that which really means how quickly can we send people in or, you know, plead guilty. So that's the system. As far as limits to individual action, you know, I think there are. I'm not gonna lie to you. I'm not gonna say, yeah, one person can fix the things that are so heartbreaking about the system, but it's through the collective that we affect change. You shouldn't have to carry the world on your back. You shouldn't come down to one person or two people to take on this burden. It is a collective burden to do better by all of us. Because again, with constitutional rights, yes, they apply to the criminally accused, but they're there to protect all of us. The Fourth Amendment prohibits unreasonable and unwarranted searches and seizures. Does that just apply to people who are accused of a criminal offense? No, it prevents the cops from coming in your house for no good reason, right? Like these things protect all of us. So the response should be from all of us. I don't want to be like, you know, Debbie Downer and say, you can't change the world. You can. You can't fix the world by yourself. That's an impossible ask. I don't put that pressure on myself. And I certainly would hope that none of you are putting that pressure on yourselves. You have to find what you care about, what you're passionate about, and fight in that lane. And good things, great things can come of that. Can I ask a question?
Please
For
do,
the
go for it.
Thank you. For the students who were in the courtroom yesterday, you saw probably a wide array of things happening on the video, perhaps in the courtroom itself, with the judge, with other attorneys. I wanted to get some feedback from people who were there as far as like questions or comments or just thoughts. Seeing Ella.
So I actually started crying at one point because I don't remember his name, but the man who was there for allegedly assaulting the police after his son was up on the roof having a mental health crisis, and like seeing the defendant like crying and like him being in that Zoom room, like not with his attorney right next to him, was, and like you could hear, like the mics were on in that room, you could hear him being like, I was really scared, like I had 2 kids inside, and like that was like very hard to watch. And yeah, so it's not really like a question, it's more of a comment, but like that. And then the other thing I noticed is like how quickly things move and like how quickly they go from one person to another. And I was like, I'm like an educated person who like is studying in this field, and it's like hard for me to follow what's going on. So I can't imagine how difficult it is to follow for like a defendant to know like what is going on. And that must be like, you just feel like you're probably lost when they're even talking about you. So yeah, more of a comment, but
I think those are very fair. Oftentimes we meet people on their worst days, and it sounds like that gentleman had things that were even worse than him facing a criminal charge, which is potentially losing his son. It can be very emotional. And again, coming down to efficiency, we move quickly in the criminal, I don't call it justice, the criminal legal system, because we want to get things done. But where's the humanity in just moving things along? Emma, what did you want to say about yesterday?
I just wanted to say I was there sitting in the courtroom, so we were able to talk to the judge when the mics were off and that kind of thing. But there was one woman there who had some drug charges against her, and she was signing. And again, I don't know the details, but she was basically being released and signing some things, and she was agreeing to do some things. And the judge had kind of mentioned that she was homeless, and not to be pessimistic, he said, but he wasn't very hopeful that she was going to be able to do the things that were expected of her. And I just felt really, I just felt like that was kind of setting her up for failure in a way. And I just felt like it would be great to see maybe a middle ground, knowing she had drug problems, not just putting her back on the streets to be homeless, and kind of knowing what you're doing. I just felt like that was a little bit sad, and I felt bad for her just because I felt like she was, like I said, just set up for failure in that situation.
Yeah, it's heartbreaking, and it happens a lot. Clients on conditions of release or probation. My hope is that she was appointed counsel, and hopefully she got a good attorney who can fight to push back against some of those restrictions and maybe help her get stable housing. It sounds like that was the number one concern, things like that. That's my hope, but that's all it is, right? So you're right to be overwhelmed by that, because it is overwhelming.
Thank you.
Yeah.
Any, we're almost at time, but any other responses to Tina's question, or any other questions we'd like to get in our last few minutes?
Yeah, I'm seeing a comment from Megan in the chat, and something that is hard because the clients are going through the worst days of their lives, and we're going through a work day. And it can seem at times that people in the system, including even the defenders, are cold or unemotional or robotic, and we're not. But I think, again, that press towards efficiency definitely makes the juxtaposition between the person who's actually going through the worst day in their life and the system players that much more glaring. And yeah, I can say I have cried in court before, though. It's happened more than once. It's probably going to happen again, because there's just some things that even, the cold robotic ones of us, it kind of breaks us a little bit. So, and that's okay too. Just not crying all the time. And when prosecutors cry, I get annoyed because they don't represent people. Any other thoughts or questions before we have to go?
Well, I just wonder, in response to what you said, what would you say to the prosecutors who say, like, I represent the victims?
They don't. Prosecutors are supposed to do justice. And I'm sure DA Sartoris will talk about this. What does justice mean? It means, I think, getting everyone involved in whatever mess there is into a better place than they were when they came in contact with the system. They don't represent the victim. They are required by statute to take into account alleged victims or complaining witnesses' thoughts, feelings, perspectives on sentencing, concerns, whatever. But they don't. And I'll tell you, we know they don't, because when there is a complaining witness who says, I don't want to proceed with charges, I don't want my husband to go to jail, they don't really respect those too much. If it's somebody asking for the hammer to be dropped down, sure, I'm advocating for the victim. But if the victim, I should say the alleged victim, because victim is a conclusory term, does not want punishment, all of a sudden the prosecutors are very much, well, we represent the public interest, so they don't represent victims.
Great, thank you so much. Well, this is the end of time for us. It's give Tina a big thanks and thank you all for your questions. And I'll see my students in person on Tuesday.
And you can certainly share my email address with anyone who wants it or needs it.
Oh, and I should say, right, for people on Twitter, follow at Tina Heat, right? Isn't that your handle?
Tina Heat 23, yeah.
Heat
Very,
23.
very professional handle that I have on Twitter.
No, it's a great account, right? If you're interested in the stuff we were talking about, follow Tina Heather Nadu on Twitter.
Thank you. Thank you so much. Thanks for all the great questions, guys.
Thanks,
Thank you
Tina.
so much.
Thank you very much.
You're welcome.
Thank you.